Denial of justice. And what does Constitution says about justice? So first is we have to mention what is denial of justice. Denial of justice refers to the failure of the legal system to deliver fair, impartial, and timely. We have to notice the keywords, those are fair. It should be fair and it should not be partial, and it should be timely. There must not be a delay. A delay in the justice is nothing but a denial of the justice. Adjudication of the disputes with respect to adjudication of the disputes and protection of rights. This concept emphasizes various situations like undue delays, when there is a delays, when you are biased, prejudice, when you are differentiating people. Biased is when you differentiate people with some pre ideas, that is with respect to caste, race, whether there might be weaker sections in the society, right? So there should not be a bias. When there is a bias, it is nothing but a denial of justice. Lack of access. They are not able to access the judicial system due to the financial, geographical, or social barriers. It also includes denial of justice. That is why we have NALSA, National Legal Services Authority, Legal Services Act of 1987. We also have Gram Nyayalayas for speedy disposal of justice and for judicial system to access all the geographical areas and all the tiers of the government. Miscarriage of justice is when you wrongly acquaint someone due to the errors in the process. It is seen as denial of justice. So we need to know what is denial of justice and what are the parameters which mention that there was a denial of justice taken place. Those are when there is a delay and when you are having any bias towards that person. Then, when that person himself is not able to access the judicial system because of difficulty with respect to financial, geographical, social, and miscarriage of justice is when you wrongly acquaint somebody. What are the constitutional provisions related to justice? Justice is mentioned in the preamble and Article 14, equality before law and equal protection of the law. Article 21 is also justice. Article 39A is free legal aid. Article 32, constitutional remedies. Article 226 is high courts issuing writs for the enforcement of fundamental rights and for any other purpose. So there are only six constitutional provisions, right? The first one is preamble. Preamble to the Constitution of India mentions justice explicitly, stating we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure all its citizens justice, social, economic, and political. This is what the Constitution clearly mentions about justice. Now, Article 14 provides equality before law and equal protection of the law. Within this is within the territory of India. It aims to ensure that all the individuals are treated equally and there is no discrimination by the state. And why does Article 21 comes here? Because we do not deprive a person of his life or personal liberty arbitrarily. We deprive no person shall be deprived of his life or personal liberty except according to a procedure which is established by the law. It guarantees the right to life and personal liberty, stating that the right to life and the personal liberty are not taken away by a person randomly. It is being deprived only according to the procedure established by law. Right. The Supreme Court has interpreted this broadly, which includes right to privacy, right to environment, clean environment, right to live with dignity. There are a lot of broad interpretation of Article 21. Again, the Supreme Court includes right to speedy trial is a fundamental right under Article 21 and a right to legal aid and protection against inhumane treatment. It is inclusively mentioned in Article 21, which is right to life and personal liberty, where procedure established by law is followed in the courts. Article 39A is directs the states to ensure that the legal system promotes justice. How does this promote justice when it is accessible to all? When it is accessible to all. This is how justice is ensured in the legal system. So, Article 39A in the Directive Principles of State Policy mentions that the state to ensure that legal system promotes justice on the basis of equal opportunity. There is equal opportunity and to provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. The opportunities are not denied due to economic or other disabilities, be social disability, geographical disability, right? Now, Article 32, it gives Supreme Court to enforce their fundamental rights, provides a right to constitutional remedies, allowing individuals approach Supreme Court for the enforcement of their fundamental rights. Article 226 also deals with the high courts, which are empowered to issue certain writs for the enforcement of fundamental rights and for any other purpose. Supreme Court judgments related to justice. Husainara Khatun versus State of Bihar. Maneka Gandhi versus Union of India. Kehar Singh versus Union of India. So we have three cases. The Indian judiciary, particularly the Supreme Court, has played a crucial role in interpreting and enforcing these constitutional provisions to enforce justice. Landmark cases are once again Husainara Khatun versus State of Bihar 1979. This case highlights the plight of under trial prisoners. For example, when somebody is caught for a crime, with caught for a crime, a person is caught for a crime and he is not proven guilty, right? The crime which he has caused is having a tenure of 1 year, or you have to pay fine for it. The court hasn't told its verdict. He is in the prison. He is an under trial and he is waiting for the police department to provide evidences in the court, and the court needs to give a verdict against him or in favor of him. But he is waiting for a more time, 3 months, let's say 3 months. Now he is he is ordered fine by the court. Here, he doesn't need to serve for 1 year, but he has served already 3 months in the court without the need, sorry, 3 months in the prison without the need of staying in the prison. This is what we say the plight of under trial prisoners, and led to the Supreme Court's emphasis on right to speedy trial. We need a speedy trial as essential part of the right to life and personal liberty under Article 21. This is Husainara Khatun versus State of Bihar in 1979. The next is Maneka Gandhi versus Union of India, 1978, when she was not allowed to go abroad. Her passport was detained by authorities. The Supreme Court expanded the scope of Article 21. The right to life and personal liberty cannot be deprived except through a procedure that is fair, just, and reasonable. So, for justice, we need to write Husainara Khatun case, Maneka Gandhi case, and Kehar Singh versus Union of India, 1989, while upholding the president's power under Article 72. This is related to mercy. So, whenever we are having a question related to president's power on providing mercy under Article 72, pardoning the convict under Article 72, right? Kekar Singh versus Union of India. This question alone has been asked as a separate MCQ. This part alone has been asked as a separate, question in UPSC. Kekar Singh versus Union of India 1989, where While upholding the president's power under Article 72, the Supreme Court also emphasized the need for a fair and just procedure. We need to be fair and just procedure in considering the mercy petitions. This is very important. So all the cases which is mentioned in the slides are very important. One needs to definitely remember all the cases and implement these cases in the examination. What is the conclusion? The Indian Constitution and its judiciary serve to strive to ensure justice through a framework of rights and protections aimed at promoting fairness, equality, timely resolution of legal matters. However, instances of denial of justice, such as undue delays in the commutation of the death sentences, highlight the need for continuous vigilance and reform to uphold these constitutional ideals. Specifying a time limit for deciding mercy petitions should be one such reform to prevent denial of justice. Now, let us see. This statement is there, right? Let us see a question which implies this statement. The question here is, this is a previous year question. Instances of president's delay in computing death sentences has come under the public debate as denial of justice. We have previously seen slides with respect to denial of justice, and we have got very beautiful points with respect to denial of justice. Should there be any time limit specified for the president to accept or reject the petitions? Now, when we are interpreting the Supreme Court judgments, we cannot start the judgments by Maneka Gandhi case. We cannot write Maneka Gandhi case here as first judgment. We have to write K.K. Singh versus Union of India. In this previous question, Husainara Khatun is in the first example, and we have Maneka Gandhi as second example, and K.H. Singh versus Union of India as third example. You can write this in this order, but when it is coming to president pardoning, this is the most important Supreme Court case with respect to president's pardoning. Therefore, in the president pardoning question, we need to write this case at first. Now, constitutional provisions related to Indian president's pardoning, right? Article 72, and we also have Article 21. Article 72 grants the president a power to grant pardon, reprieve. So, pardon, reprieve, respite, remission or punishment, remission of the punishment, or to suspend, remit, commute the sentence of any person convicted of any offense. Article 21 protects the right to life and personal liberty, stating that no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, when we are writing Supreme Court judgments, we can include three judgments at the max. Now, here, the first judgment is K.H. Singh versus Union of India. Sher Singh versus the state of Punjab. Shatrughan Chauhan versus Union of India. This is a recent case. 10 years of Shatrughan Chauhan versus Union of India. Right. K.H. Singh versus Union of India. Supreme Court held that the pardoning power of the President under Article 72 is to be exercised by the President on the advice of the government. It is exercised on the advice of the government. To be noted, very important point. President cannot act on his own discretion. Even the pardoning power is to be exercised on the advice of the government and is not subject to judicial reviews except on the grounds such as malafide or an arbitrary exercise of the power. It is not subjected to judicial review, and you can also include the point which is mentioned over the previous slides. The Supreme Court also emphasized the need for a fair and just procedure in considering the mercy petitions. It must be fair and just procedure, right? You can include this point also. So the first point is the president cannot act at his discretion. He needs to consider or he needs to act on the advice of the government. Second one is it is not subjected to judicial review except on the grounds of limited on limited grounds such as malafide or arbitrary excess of the power. This is K.H. Singh versus Union of India, 1989. Then we have Sher Singh versus Union versus State of Punjab, which was in 1983. Supreme Court observed that the undue delay in the execution of the death sentence could be a ground for commuting the death sentence to life imprisonment, as it would be inhuman to keep a prisoner under shadow of death for an infinite period. When you are not reacting to the petitions, when the president is when not the president, when there is a delay in the execution of the death sentence, it is considered as a lifetime imprisonment because the death sentence keep on gets delayed. It is inhuman to keep a person under death sentence for an infinite period because when a person is having death sentence, let's say within 10 days, imagine his mindset, and tomorrow he is 9 days are over and tomorrow he is having death sentence, but suddenly his petition is delayed, and due to the delay in this petition, his sentence was also delayed. Now he has to wait for another 20 days for his execution, and he has to suffer the mental disorder because within 20 days he is going to be executed. Likewise, if it is keep on postponed, he will have mental trauma. This is an inhuman act. So the Supreme Court in the Sher Singh versus the State of Punjab in 1983 it stated that the Supreme Court observed that undue delay, there is an unreasonable delay in the execution of death sentence. This is related to the execution of death sentence, right? This is related to how the president must act with respect to his pardoning powers. This is also under the advice of government. Here in the Sher Singh case, what do? You should not have an undue delay in the execution of death sentence because it could be ground for commuting the sentence to life imprisonment, as it would be inhumane to keep a person under the shadow of death for an infinite period. Shatrughan Chauhan versus Union of India 2014. Now, here the Supreme Court laid down guidelines to prevent inordinate delays in the execution of death sentence and ruled that prolonged delays in the mercy in deciding the mercy petition shall be a ground for of the sentence to life imprisonment. And the court also recommended that mercy petitions should be decided expeditiously. Now, arguments for imposing, what are the arguments in favor of imposing a time limit and arguments against imposing a time limit? Right to life and personal liberty under Article 21, denial of justice, judicial certainty, humanitarian grounds. Right to life and personal liberty, Article 21. When there is a prolonged delay in the execution of death sentences, it is serving mental anguish and it is a torture. It violates the right to life and personal liberty. When there is a prolonged delay, this is with respect to death sentence and Article 21. When there is a prolonged delay, it can cause severe mental anguish and torture, which violates the right of a person to life and personal liberty. When there is a denial of justice, denied justice, delays can be seen as a denial of the justice, not only to the convicts but also to the victims and the families who await a closure. Victims and the families expect a solution, they expect a verdict, right? When the verdict keeps on postponing, it also causes a denial of justice to the victims and their families. Judicial certainty. When there is a time period specified, it would create certainty and predictability to the legal processes, ensuring the justice is not duly delayed. Humanitarian grounds. Keeping convict on death row for extended period is inhumane and can amount for a form of cruel and unusual punishment. It is a punishment, right? When there is arguments in opposing the time limit, when there is a complexity of the case, each case is having a unique complexity. President along with the government may require considerable time to thoroughly examine all the aspects before making a decision. Executive discretion. The power under Article 72 is an executive prerogative, and imposing a strict time limit would undermine this discretion, right? It is a discretion. It is not a compulsion for the executives, it is a discretion for an executive. There should not be any discretion, a compulsion should not be there, right? Executive discretion, the power under Article 72 is a executive prerogative and imposing a time limit would undermine this discretion. Judicial review. Judicial review can already review case. The judiciary can already review cases of undue delays and commute sentences if it finds delay to be excessive and unjustified. You can do judicial review. The first thing is the cases are complex. The second thing is it is a discretion and it is not a compulsion. It is a discretion. And the third thing is when there is a delay, you can go for judicial review. The judiciary can intervene, right? These are the points against the fixing of a time limit for pardoning of precedent. Now, what is the conclusion? Giving the implications of prolonged delays on the fundamental rights of convicts as recognized by the Supreme Court, as already recognized in the Supreme Court, even mentioned that there needs to be a time limit, right? There is a strong case for specifying a time limit which the president must decide on mercy petitions. Such a measure would uphold the principles of justice and human dignity while respecting the constitutional framework. However, this time limit should be reasonable enough to allow a thorough and just examination of each case, balancing the need for executive discretion with the rights of individuals facing the death penalty.